Hey, Ultra Legal Warriors, should you represent yourself in a DUI case? Well, instead of just saying no, I'm going to instead talk about the most common mistakes that people make when they attempt to represent themselves in a DUI case in Washington State. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it, more people get the help they need. Now I'm just going to jump right into it. Let's start with the basics. What do you mean by DUI? Well, that means driving under the influence. In Washington State, driving under the influence means that you are driving with a breath test of 0.08 or more within 2 hours of driving for alcohol consumed before or during driving, or your ability to drive a vehicle is affected in any appreciable degree regardless of what your breath test is, or if you have 5 nanograms or more of active THC marijuana in your system when they do a blood draw. Again, it needs to be within 2 hours of driving. So if it's outside of 2 hours of driving, it's not an automatic you win type stuff. They can extrapolate back and try to claim what you were. So that's what a DUI means. And you could tell by that complicated explanation I just gave, you could already see what's the number one mistake someone who tries to represent themselves makes in a DUI is big mistake is they don't educate themselves on the law. You know, what is the law, right? Even a defense attorney of 10 or 20 or 30 years, we're still always learning new things about the law when it comes to a DUI. So the number one mistake someone makes representing themselves is they just think, well, if I'm not 08, if I'm 07, I'm innocent. They can't prove me guilty. Remember, I've already talked about 08 is not the legal limit. That's what the public calls it. I call 08 the illegal limit. Illegal. Which means if you're above 08, you're automatically illegal. If you're below 08, you are not legal. You're just not. They're still going to try to prove you guilty, and they may be successful. So if you're going to represent yourself, make sure you're trying to educate yourself on the law. The number two mistake people make who represent themselves on a DUI is they don't request a Department of Licensing hearing. If you have a breath test 0.08 or more, or a refusal, you're going to get a suspension from the Department of Licensing of Washington State, even if you don't have a Washington license. If you don't have a Washington license, they're going to suspend your privilege to drive. You have 7 days from the date of the event in most cases, there's some exceptions out there, to request a licensing hearing, and it costs $375. And so many people who aren't represented, at least at the time the 7 days comes around, they don't do it. You know, I don't want to spend the $375. I don't even know what this form means, or maybe you didn't even get a form. And if you don't request that licensing hearing, not only are you automatically for sure going to suffer a suspension, and that's not good, since most suspensions will start 31 days after the event. More importantly, you're giving up one of your most important ways to gather evidence in the case that does not involve the prosecuting attorney. A licensing hearing is a telephonic hearing done on police reports without a prosecuting attorney involved because it's civil, it's not criminal. The person who decides the case is the hearing examiner. That's just someone who has a job for the Department of Licensing, not even necessarily an attorney. And they're going to hear the evidence and decide the evidence, but there's no prosecutor from the government listening in on the evidence. So if you have an attorney, and you can do this yourself too, if you can figure out how to do it, you can subpoena the police officer to appear at the telephonic hearing. And guess what? That police officer is not in a courtroom. They might not even be in the police station, right? They might be at their home in their jammies, right? You know, because if they stopped you at 2 a.m. and now it's 2 p.m., what are the odds they're working at 2 p.m., right? It's a whole different shift. And so that means sometimes they're a little bit casual with their answers. And they're recording. They are recording those answers. And so if they mess something up, your attorney, if you had one, or you, if you don't, you can get that tape and try to use it to help your defense case. So many times we'll get key evidence in a Department of Licensing hearing that we never would have gotten in the criminal cases. Most cases don't get to motions, they don't get to police interviews, and if they do, there's a prosecutor there to fix everything. And in this case, there's not. So that number two mistake is not requesting a licensing hearing, and not just because you can beat the hearing, because you're giving up a lot of evidence. Number three mistake we see is not requesting the breath test room video. Right? Even smaller law firms still don't do this. I'm guilty of that. When I was a newer attorney, I didn't know anything about breath test room video, right? Who would have time to look at all that stuff? But in many breath test rooms, there's a video that's taken, and it's not part of discovery. Prosecutor will never get it. The cops will never collect it. And that video typically doesn't have audio, but we can watch and see, was the police officer following the Washington Administrative Code in how they administered the breath test? Because they're sure as heck going to swear they did. They're going to check every box. And guess what? The boxes they checked, they're pre-marked in bright yellow, right? Check the bright yellow one, right? It's amazing. I mean, it's just unbelievable, but that's the world we live in. But if we can get that breath test room video, sometimes we can prove that the officer did something wrong. They left the room, they blew the observation period. You have to observe people for 15 minutes to make sure they don't vomit or put something in their mouth. Sometimes someone could put something in their mouth in the video, and that's going to invalidate the breath test. But the officer's already pre-marked the yellow box, that didn't happen. So the only way we can show it did happen is to get this piece of evidence that does not exist in every case, but where it does, it can't hurt us, it can only help us. Because if there's something right with it, well, they already checked the box, it was right. If there's something wrong with it, boom, we have a secret weapon to try to get that breath test thrown out, which is going to totally affect the outcome of the case. But if you don't have an attorney, are you going to know to do that? No. Most attorneys don't know to do that. And therefore, that's mistake number 3 that can apply to many, many people. Mistake number 4, well, communicating with the prosecutor, right? You don't have an attorney, you're forced now to communicate with the prosecutor. And guess what? Anything you tell the prosecutor can be used against you. Well, prosecutor, I wasn't that drunk. Well, you were drunk? Okay, that type of thing. And so the mistake is now you are going to communicate with the prosecutor in not only a way that may provide evidence against yourself, but more importantly, you're just going to piss them off, right? Because it's personal to you. You may say things they don't like, and they may not be that nice to begin with. Prosecutors have a hard job. Really good defense attorneys spend a career trying to make sure that they don't give prosecutors a reason to be mad and take it out against clients, right? And how we talk to someone, right? You don't have a case. Could really make someone come back at you hard if you're a prosecutor. Hey, I don't think your case is that great. Here's the reasons why. Here's all the good stuff my client has done. Prosecutor can hear that. If you're representing yourself, it's almost impossible for you to talk like that because it's personal. So that's mistake number 4. And I think I'm going to have to quit numbering them because there's going to be so many for people that I see that do attempt to represent themselves. Mistake number 5 is talking to the court. How you talk to the court, right? The court hates an unrepresented person, right? In my opinion. It causes headaches. They're worried about protecting the unrepresented person from what they don't know. It makes the case go forever, and it's just an unfair fight. A judge does not like to watch an unfair fight. We got a gunslinger and the prosecutor, and we got a little baby in a baby carriage that they've given a pop gun to trying to fight back, right? It doesn't work. It's not fair. It puts you in bad light with the judge. And I'm going to try to cut this video short at number 6. But number 6 mistake is people not taking affirmative steps when they represent themselves, right? You need to do things. You need to do an alcohol drug evaluation. You need to follow up with alleged recommended treatment. You got to do a victims panel. You got to do all these things. And people non-represented think, why should I do that? I'm not guilty, right? It's going to be an admission of guilt. And it's one of the most important parts. Mitigation is one of the most important steps in any type of criminal negotiation, minus major felonies. Major felonies, we're just going to trial, okay? We're talking to DUIs here. This wouldn't exactly work at a vehicular homicide DUIs. Some of it would, but maybe not the negotiation part. But you need to get these affirmative steps done so the prosecutor can feel they're part of the solution when hopefully your attorney talks to them. If you don't do anything, I mean, the rule of thumb of a prosecutor is I won't even talk to you until I can see an evaluation and something's done because, if you're asking me to take a risk as a prosecutor and reduce the case off of a DUI, I don't want my name in the paper when this defendant kills someone in 6 weeks, right? Because what's in it for them? And so it's a very complicated process. A DUI has, so many ins and outs. I've not covered what you don't know about, case law or how the breath test works or how to object to blood evidence or any of this. It's obvious you should not represent yourself for a DUI, but I figure that you should know here's some reasons why, not just because some greedy lawyer wants your money. No. Defense attorneys, the good ones, they're out there to help people, and nothing sort of hurts our heart more than seeing someone going into court unrepresented and therefore having no chance for what we would consider a fair outcome. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward. We will be there for you. Thank you.